May it please to record, my name is Nguyen Initial A. I'm here on behalf of my client, Mr. James Beeston, who's a 14 years old Aboriginal male from Townsville. My client, Mr. Beeston, was charged with 5 counts of breaking and entering premises and committing an indictable offense under Section 420 of the Criminal Code. He was also charged with 32 counts of burglary under Section 419 of the Code. Today, with your Honor's permission, I'm doing a recording for my client's pre-trial hearing. Your Honor, in the pre-trial hearing, the defense submit to request a piece of evidence to be excluded according to Section 590, capital A, subsection 2E of the Code. This evidence is Mr. Beeston's admissions to the offenses. The defense request is based on 2 grounds. Firstly, I submit that the evidence was obtained by the police officers with a sheer breach of a fundamental right of my client, which particularly the right to silence. This evidence, if admitted to the court, will be too prejudicial to the prospect of a fair trial to my client. The second ground of the defense request is excluding evidence based on discretion relating to public policy. During the questioning in the police car, it has an obvious appearance of gratuitous concurrence during the questioning. It could lead to the weight of the evidence significantly reduced. In the respect of the first submission, the defense submit that the 2 police officers who first arrested my client and questioned him in a police car have failed to comply legal obligation of the accused under the Police Powers and Responsibilities Act, the PPRA. Your Honor, when my client was first approached and arrested by 2 police officers, they did not inform my client about his right to remain silent, which clearly stated in Section 397 of the PPRA. I believe that this intention mentally affected my client and had him answer the following questions of the police officers without knowing he may not need to do so. Additionally, no one from the police department and even the social worker Roger Smith, who was with my client during the interview, seemed to have any effort to tell my client that he has his rights during the process until I finally had a chance to talk with my client. My client is just a 14 years old boy from Aboriginal culture background and have very limited knowledge about our legal system. He should be acknowledged about all his rights, including the right to remain silent. In this case, the police officer did not treat my client with a key rule of criminal proceeding that everyone is innocent until proven guilty by a decision of the court. I believe that they treat my client as a real criminal without decision of court. Simply, they should finish the procedure to put Mr. Beeson into prison. Hence, the procedures relating to Section 397 were not done effectively, with the purpose to seek a fair treatment for my client. Therefore, the defense counsel submits to your Honor a request to exclude this evidence due to discretion relating to fairness. In terms of the second grounds for excluding this evidence, the defense submit that the unlawful technique in obtaining evidence of the police officer lead to the damage of public interest and also my client as a member of the community. We refer to the case Bunning and Cross, where the court identified 5 main elements to be applied. I would like to draw an attention to the second element of whether or not the illegality result in the evidence obtained being less reliable. As I have explained previously, with my client's background from Aboriginal culture, he should have been questioned with proper care and consideration to ensure all the information collected during the interview and the questioning was correct and in respect of the real meaning of my client's answer. During the questioning in the police car, I believe that Your Honors will notice a very usual and common error in communication with Aboriginal coast people and Torres Islanders, the gratuitous concurrence. We should also know that the tendency to agree with the questioner. When the police officer asked if my client committed those offenses, he first nodded down and looking down, and then say, yeah. For those serious accusations, this should not be considered as an answer yes with those kind of responses, especially from a person from Aboriginal culture. Therefore, Mr. Beeston's answer during the questioning and also the interview should not be considered, as he admitted his involvement to all those offenses. If Your Honor accept this evidence, it will highly encourage unlawful and shoddy practice of the police officers who will not take reasonable care to Aboriginal people and Torres Islanders, would lead to the result of unreliable statement. Therefore, to protect the community, especially for those who are from the similar origins as my client, I submit that this evidence should be excluded. Your Honor, those are two grounds that I submit to seek an exclusion of the evidence. At describing these two grounds, the defense believes that it is likely for the accused to be wrongfully convicted with this piece of evidence is admitted. I hope that Your Honor will consider my request with a comprehensive perspective, including my client's background and also the police officer's unlawful evidence obtaining technique, to seek untrue confession of guilt from my client. Thank you.